Now, reactions have not stopped trailing the conviction and sentence of the senior advocate of Nigeria, Joseph Nwobike, on charges of attempts to pervert the course of justice. While some people feel that the senior advocate got off lightly, others feel that with a conviction, justice has been served. I have the views of some senior lawyers on the issue.
That law says when you attempt to pervert justice, you are liable for 2 years imprisonment. The law did not say you must be given 2 years imprisonment, but you are liable. So you can be given up to 2 years. The gentleman received 1/24 months. That's 1 out of 24 months. When you now do the mathematical equation, 1/24 times 100/1 is not up to 5%. That's not fair enough. Particularly so since the offender happens to be a legal practitioner. And the legal practitioner happens to be a senior advocate of Nigeria. Lawyers are said to be priests in the temple of justice. Now, perversion of attempt to pervert justice should be considered a very serious crime indeed.
The section did not state any minimum conviction, any minimum penalty, so to speak. So, but the jurisprudentially, or I would say by the law, judges are allowed in a situation where the section of the law provides a maximum number of years, so to speak, or maximum punishment. The judges are allowed to give lower. The only thing the law does not allow is that they cannot give more. So because I think generally within the public space now, people have been so concerned about why would the law provide for 2 years and a judge is giving less, so much so that it was just 30 days, and this on 12 count charges, and it will run concurrently. So it presupposes that there is some underhand arrangement. I want to disabuse the mind of the people that the law allows a judge in a situation where the maximum is prescribed to come down below.
If the judge actually felt that Nwobike SAN is guilty of that offense, I want to disagree with the sentence. Honestly, I think some days before the judgment, we were told that there are pressure upon the judge, and the sentence can only confirm that. I am not saying I have a proof of that, but the sentence can only confirm the rumor. You understand? Because I was the opinion that I think the law in that regard prescribed 2 years. Why I know that the judge may sentence for that 2 years or less than that year, I sincerely believe that a month is not even a slap in the wrist, is probably a rub in the wrist. So I'm not in agreement with that sentence. I am not. For goodness sake, I am not. If you want to set him free, based on evidence, set him free. If you are convinced he has done it, I do not see why it should be less than 6 months, honestly, sincerely speaking.
The senior advocate has filed a notice of appeal and indicated a readiness to challenge the judgment all the way to the Supreme Court. So we'll follow the issue closely and keep you updated on the developments as they unfold. And it's on that note we wrap up today's episode of the program. Please feel free to send in your comments on any of the issues we discussed today. Do also remember that you can watch this episode and past episodes of the program on our YouTube channel. I'm Shola Sheyeli. Many thanks for watching.